Today I'll be talking about why starting early matters more than getting it perfect when it comes to achieving financial independence. This is especially important for those who are raising young kids, but most definitely women. Hi, I'm Melody Edwards, a Senior Financial Advisor at Evalesco Financial Services. Welcome to the Healthy, Wealthy and Happy podcast. Today I'm joined by the fabulous Jacinta Watkins, who is an estate lawyer, once again, second time appearance on our podcast, to speak all things estate planning. Welcome to the podcast.
Thanks for having me, Melody.
So in your career as a estate lawyer, you must come across a lot of interesting scenarios and challenges that people face often when it comes to dealing or thinking about their estate planning. So we'd like to delve into a little bit more around those and share your learnings with our listeners today. So firstly, what would you say when people are talking about estate planning, often they think about what's fair or what's equal, which often comes up as a common thing that we hear as advisors as well. People wanting to leave things equally to their beneficiaries, but that is obviously not necessarily the same thing. So what would you say to fair versus equal?
Well, often it's mainly parents that they believe that they need to leave their estate what's called equally to their children. But often what is the case, particularly in larger families, is that one child or two children may do the lion's share of helping parents, particularly in their older years, or they may be assisting the family significantly in growing a business or with renovations to a family home or a farm, so that builds the wealth in the family, but only a couple of the children are part of that. And so they come round when somebody's passed away and say, well, that is not fair. And so I hear that word all the time. It's not fair. Sometimes it might pass the pub test, sometimes it might not. But fairness matters in a deeply human connection. But fairness is subjective. So equal is not always fair, and fair is not always equal. So when someone says, it's not fair, they often say, because I'm hurting. So we sort of delve more into the social science part of that rather than the legal process. The legal process can't, heal what's fair, but a careful, well thought out estate plan can do is create clarity and can reduce future conflict in a family while someone's still alive or after they've passed away.
That's a good point. So when you're talking about these things that arise, is it often after someone's passed away or when they're talking about creating their estate plan?
Often after someone's passed away is when the family finds out what's either been left to them or in other circumstances what's not been left to them. It can be during someone's lifetime if they are pressuring, particularly an older person to change their will because they might deem it to be not fair, or it can come up particularly during someone's lifetime when they're doing their estate plan. In blended families is a really big issue for so many people these days, and I see it all the time is what's fair for children from a prior relationship, and then particularly in a long-term second relationship, if it doesn't really matter about the number of years, but sometimes in a 30 or 40 year second relationship, for that spouse to be not had been provided for adequately for the rest of their lifetime can be seen by the children from the first relationship as not fair. If they've, the new stepmom or stepfather is left more than what they think is fair. So it's very subjective, and even coming at it from a different perspective in New South Wales, if somebody wants to make a claim against an estate post-death, what that is called in New South Wales is a family provision claim, and a claim for either more than what they've been left in a will, or they can be left if they've been left out entirely.
Yeah.
And that's based on their needs. However, the law sees that how that works is based on their needs. But in reality, what families think is that that's not fair, that someone's either made a claim or that's how the law works.
Yeah. So I can imagine there's a lot of issues and challenges that arise from blended families, especially in those dynamics. So what other issues or things that come up, and how do you see them being solved when you're doing their estate planning?
Well, I see a very common thread through particularly parents coming to make their wills for when they want to work out how to divide their estate amongst their children, if they've got, a spendthrift child or a child that has been bankrupt previously, or they're, in a high-risk business that may be something that could cause them to become bankrupt in the future, or, not be able to manage their finances properly. Or it can often be, if they think that their child is in a relationship that they're not really that happy with their partner, they may never tell the partner, but I hear about it. And they are worried about, if they leave their, child a large inheritance and then they separate from their partner, what that partner may be able to get, through a family law separation. There are other circumstances where it's obvious to a parent, that they can't leave money to a child because they know that their child's a gambler, or, they know that they've got, an other type of addiction like an alcoholic or something like that. And parents are very concerned about where their inheritance may go. And sometimes they want to skip that through that generation and give to the grandchildren, particularly if their child is, maybe have subjected to one of these, like an addiction or something like that. So it's quite concerning, particularly if there's large sums of money.
That's right. There's a big wealth transfer, and so want to protect that for the beneficiaries, but also in a way protect them from this.
Yes.
So what are the common ways to address those from an estate planning perspective?
Depending on the size of the wealth that can be transferred down, or would likely be the size of that in the future, I would often recommend for a family for the will maker to prepare what's called a full testamentary trust will. It is a little bit, and it can be like a discretionary testamentary trust, and that then allows flexibility for the family. That then allows flexibility for the people that are inheriting receive their share of the inheritance. They can use that for tax purposes through the testamentary discretionary trust, or it can also, if a separate trustee is appointed to manage that trust, or jointly with the beneficiary, that can protect them from themselves because there's somebody else involved in managing the trust, so that they don't have full control of it, but they still have access to the funds, and they get the benefit from it. So that's often what I recommend, depending on the circumstances, and we work well with the financial advisor in relation to working out what the best way to formulate an estate plan is.
Oh, brilliant. So with testamentary trusts, what are some important sort of factors to consider around who to appoint as a trustee to help manage that? Do you find from when you have those conversations with your clients?
So I have a variety of people that want to appoint, often siblings. So, for example, if there's, say, 4 children, there might be 2 children together, sort of 2 and 2, or somebody separate, like a very close friend might be the other trustee, or they may just be the trustees and the beneficiaries aren't a trustee of their trust, depending on the age and how well, what the parents deem the children might be able to cope with in the future. It's not always, parents wanting to set up a testamentary trust will. Sometimes, we have will makers come into the office and they don't have children, so they want to leave their estate to nieces and nephews, and particularly if they're younger and there's a significant amount of money, they would like that to, them to be able to have the benefit of that in their as those children grow up. So that gives them protection from their parents spending the money, and also can assist with tax through the testamentary trust. They have to obviously get the advice at the time, depending on what the tax rules are, but it can be a really good vehicle for generating wealth through a testamentary trust well after someone's passed away.
Sounds good. Okay, so a common scenario that we sometimes come across is an estranged family member who, usually a child who's kind of cut themselves off from the parents, or, they don't have a great relationship anymore. So how do you navigate that in terms of, thinking about your estate plan and what potential issues might arise, for your kids when you pass away, or the beneficiaries that you intend the money to go to?
Well, in New South Wales, I have heard a number of people come and see me who may have historically made out a will and been told, oh, if I leave someone $1, if I leave that, child I might not have seen for a long time, or children from a previous relationship, if I leave them a very small amount of money, then they can't contest the will. Mm-hmm. That is actually not true. The Succession Act sets out the criteria of eligible people that can make a claim on an estate, and whilst you may not think that's fair or may not pass the pub test, that's what the law says. And those categories of people are spouses, in some circumstances former spouses as well, if they, depending on what the circumstances are, so it's very unique each case. Children, in certain circumstances, children and other members of the household. So the law sets out who can make those claims, and it's a majority of it is based on their needs at the time, not now when the will's being made, but at that time in the future. But it should be taken into consideration if a parent who's leaving a child out or leaving unequal shares. The reasoning behind that, that doesn't stop a claim being made in the future, but they need to, really consider who would have a claim on their estate and why they may not be making that provision for themselves. So they have free will to, if the person making the will has capacity to make the will at the time, they're free to make the will however they choose to, but it comes with consequences depending on whether they're leaving a child out or not. Often I say, particularly, possibly not in when there's estranged family members involved, but if you're not sure and you're trying to work out how to leave your estate, get your family involved. I'm a collaborative lawyer as well, and I know that Melody's in the process of becoming trained to be a collaborative financial advisor, and that it's a process that we can involve the whole family in, and you can hear from your children in a unique environment that involves scaffolding that helps the family be able to say what they need to say in a nurture environment with assistance from social scientists and lawyers and financial advisor to make sure that everybody's on the same page and they know what's going on and what's going on in their life. You're not left guessing what you might want to do. And it also assists particularly for a financial advisor who may be assisting parents in generating their wealth. Where's that going to go? And then the parents can start, teaching and educating their children. It's a very common thing that I've heard, and you probably hear it too. Parents wonder, got all of their finances all well laid out, and their wealth is, managed for quite a number of years and projected. And then they wonder, do my children even know how to, balance a spreadsheet or work out, their spending habits? And it worries them. They're really worried about, if they're handing over all this money, it's just going to be blown in 5 minutes. So that's a big, big consideration for families.
That's right. And I think it's part of the discussions that I'm seeing more and more with clients as well is around that they've created this wealth, and how do they pass that on and enable their kids to be good stewards of that money too. Of course, you don't want them to sacrifice anything, but you also want to make sure that they're looking after themselves and their future generations as well.
Yeah, I think that's one of the most important things. I think sometimes, depending on the age of the person who's making the will, it's often they're sort of thinking about, helping out their children, but, grandparents love being grandparents. And so thinking about that next generation, and particularly for people, living in the greater Sydney area, it is very expensive to live here. And they're thinking, how are my grandchildren even going to, get a deposit for a house? So they like to leave some, money for their grandchildren. But then that can upset their children if they've skipped over their child or they're getting less of a percentage. But if everybody knows what's going on and they're not just told, but they're part of the process, and as to why everybody can work together, it often works out to be a really great estate plan, which is something that can change over time as the family dynamics change. Yeah. It's not set in stone. But if everybody works together, it's always a much better outcome.
That's true. So when they obviously collaborative practice in estate planning is a relatively newer practice in Australia, especially. Where do you find that would be work the most effective for people who are coming across potential issues, or where that they think, well, how do I solve this? What would be the triggers or questions that collaborative practice might be a solution to fit that problem?
Well, I recently so I was part of a collaborative practice process for an estate planning matter, and the outcome for that family was something very, very different than, when that person passed away, the outcome that would likely happen if that estate was contested. The tax that would have been saved for the way the estate plan was structured and the way the wealth will be divided when someone's passed away was a lot. So each matter is very unique, and it allows just people to speak freely and to know that they've been heard. And I think that comes back to that fair versus equal, and it's the human part of that rather than the legal part of that, and then the financial numbers part of that. Everybody's life can fit into a spreadsheet or can fit down, a funnel of what the law says. But what does your family need? And how does that estate plan need to look for your family? Each family is individual, even though, the law says that this is the process or the figures say this is the process. Better to have that conversation now than to forever think I should tell anybody what's in my estate plan. I think it's time people, did start talking about that openly, particularly when you're working well with a financial advisor. You want your children to be able to come back to that financial advisor and carry on what you've been, growing, so that it grows more for that family, so that there's more to be divided through the generations and not less.
That's excellent. So do you have any final thoughts or tips that you want to share with when people are approaching challenges in sometimes it could be, the attitude is it's just too hard to think about. I'm just going to, say that, procrastinate and save that for later and not have and leave it for another day. Any sort of tips that you would share to say to really get that process started or start, that journey?
Just start the conversation. Just come for an appointment. You don't have to do the will that day. Just start thinking about it. If you don't know what to do, sometimes I have people make a will. They've been worried for so long about how to do it. Then they just come in. They just go, I just do something. Better than nothing. And if you make that will now, you can always change it in the future. It may never be perfect, but just start somewhere. I've had, a number of people that have come in recently. Somebody's passed away and they've prepared a will, like a post office will, and they've not completed it properly. Things haven't been witnessed properly, and it makes just really hard work for the people that are left behind. So I say that it's a gift to the beneficiaries that you're leaving behind, particularly if they're your children who have often done the hard yards, along the way, especially for the elderly clients. They've been caring for an elderly parent for, quite a long time. Give them the gift of having this at least sorted out for the most part. That's my final tips. Just start the conversation.
Brilliant. Well, thanks for sharing so much, Jacinta. Always a pleasure to have you on and sharing your expertise.
Thanks.
If you'd like to find out more, we'll shoot through Jacinta's details in our links or reach out to our office. If you'd like to chat with an advisor, as always, you can book in a chat on our website or reach our office. But join us again for another healthy, wealthy and happy podcast.